Good afternoon. We're going to go ahead and get started now. For those who don't know, my name is Donald Harris. I'm the Associate Dean for Academic Affairs, and it is my honor and delight to welcome you here today to the 2023 Clifford Scott Green Lecture. It's really nice to see so many folks here. I'm going to keep my remarks fairly brief, in part because I don't want to take away valuable time from our excellent, incredible speaker here. But I do want to say a few things about this event and about the person who it honors. As my first order of business, though, I want to extend greetings from our Dean, Rachel Impoverishes. Rachel, when you see this, you'll know that you had shout outs. She couldn't be here today because she's at an out-of-state commitment. But in her stead, following my brief welcome, Professor Alice Abreu will introduce our guest speaker, Dorothy Brown. I should also mention that for those who don't know, we have a new acting president of Temple University. Yes. Our own Joanne Epps. She couldn't be here. She's in Harrisburg right now, but she is on her way, and so she'll meet us at the post-lecture reception. I enjoy this event, and I enjoy this event because of who it is, who we are honoring here. It's wonderful to see so many people, alumni, friends of the school, colleagues, but also students. And I think I enjoy this for the students because we don't get to do this often. We get to do this once a year, but it is such a uniquely rich learning experience. And for students to be able to get this opportunity, even though it only happens once a year, I think you leave with lessons and messages from those who speak on behalf and in honor of Judge Green. And those messages are something that's long lasting. So I appreciate you all being here. I think it's also fitting for everyone who had the honor of knowing Judge Green that his depth of caring for Temple Law students was unsurpassed, and that he would be deeply pleased to see all of you here today. I'm delighted to welcome Judge Green's wife, Carol Williams Green, who I met. Carol has been and remains a treasured friend of the law school, and your dedication to Temple Law School, to its mission, to its programs, and particularly to its students has been unwavering. And so thank you for all that you have done and continue to do for Temple. We are forever in your debt. Oh, absolutely. Is Bob here? I'm looking to see if former Dean Reinstein in the house? No. Okay. I did not personally know Judge Green, but I've talked to people about him. I've heard about him from those who were fortunate enough to know him, and uniformly, they praise him as a man of keen intellect, of empathy, and someone who commanded respect. The esteem in which he has been held, in which he is held. Okay. A moment. The esteem in which he is held is a testament to his compassionate and generous nature, as the many law clerks, interns, students for whom he was a mentor and a teacher will attest. He was also a brilliant lawyer and jurist, a dedicated civic leader, and a fearless advocate. From Judge Green's membership on the Leah Corus Committee, which exposed racial bias in the assessment of Pennsylvania bar applications, to his involvement in creating the Temple Leap High School mock trial competition, and his service as a founding member of the Temple Law School Board of Visitors, Judge Green was instrumental in confronting the barriers of racial and economic exclusion from our profession. Judge Green's work and service have done more than shape this law school. They have permeated our character and have become part of who we are as an institution. His vision and his voice have transformed this school and the Pennsylvania legal community, and we are all better for it. Thank you, Judge Green. In a moment, my friend and colleague, Alice Abreu, will introduce Professor Brown. But before that, while I still have the podium, let me say a few words about Alice. She is the inaugural holder of the Honorable Nelson A. Diaz Professorship, and she is a national leader in both low-income tax policy and practice and diversity at the tax bar. When I say that Judge Green's legacy has permeated this law school, Alice's work is a shining example of what I mean. She has been both brilliant and tireless in her work to create opportunities for diverse students in tax, to open up tax practice as a way to do social justice work, and to bring meaningful relief to poor families in the communities surrounding Temple. It's no exaggeration to say that her work inspires me, and her friendship is a gift. Please join me in welcoming Alice Abreu.
Thank you, Don. And it is my distinct pleasure and honor to introduce Professor Dorothy Brown, whose work in tax has been both path-breaking and paradigm-shifting. Professor Brown is the Martin D. Ginsburg Chair in Taxation at Georgetown, where she teaches critical race theory, federal income tax, and partnership tax. And before going to Georgetown, she has had an illustrious career. She has been the Asa Griggs Candler Professor of Law at Emory Law School, as well as holding several executive positions at the university, including Vice Provost for Academic Affairs and Senior Advisor to the Provost. Earlier in her career, she taught at several other law schools and won teaching awards at every single one. In addition, in 2018, she was the co-recipient of the Clyde Ferguson Award, which is given by the minority groups section of the AALS, the Association of American Law Schools, to outstanding law teachers who have achieved excellence in the areas of public service, teaching, and scholarship. As if all of that weren't enough, Professor Brown is also a prolific scholar, having written or co-written not one, but 2 casebooks in 2 different fields, critical race theory and federal income tax. She has also published dozens of articles, essays, reviews, book chapters, and testified before Congress on numerous occasions. As you can see, Professor Brown is an academic star, but in the spring of 2021, she published a book that made her a national star to the general public, appearing on popular TV shows like The View and CNN, MSNBC, Bloomberg, and publishing opinion pieces in the New York Times, the Washington Post, the Atlantic, Forbes, and the National Law Journal, just to name a few. The book she published in 2021 is The Whiteness of Wealth: How the Tax System Impoverishes Black Americans and What We Can Do to Fix It. And I want to conclude this introduction in Professor Brown's own words by reading just a few passages from the book, which I think has one of the best opening lines that I have ever read in any book. The opening line of The Whiteness of Wealth is, "I became a tax lawyer to get away from race." Professor Brown goes on. She was born and raised in the South Bronx in New York City. Her father, James, was a plumber who worked without benefits for a private company because back then, Black men couldn't join the union that controlled the good public sector jobs. Her mother, Dottie, was a nurse and a seamstress who had left her job as a garment factory floor girl because she knew she could do better work than the white seamstresses who got all the opportunities. They lived in a 3-family house at 1061 Morris Avenue, purchased with the help of a $6,000 loan from her father's white boss, and rented the upper and middle apartments to Black tenants who became like family. They didn't have a lot, but they had food on the table and clothes on their backs, handmade by her mother, of course. And she and her sister had a little bit of spending money. Her parents had lived through the Jim Crow era and faced laws dictating what they could earn, what they could own, and where they could live. But they were determined that their children's generation would be educated and live on their own terms. As a little girl, she believed that that was a possibility. Professor Brown then recounts an incident that occurred when she was 9 or 10. She saw a handcuffed Black man being beaten by a white police officer. And what she then says is the following: "And that's how I became a tax lawyer." She says, because she learned early on that people might look at her and see Black, but as far as the tax law was concerned, the only color that mattered was green. So she attended Fordham University and majored in accounting, got a law degree from Georgetown, and earned a master's in tax law from NYU. Tax law was about math, and she was sure that she had chosen a career where race had nothing to do with her work. She then says, "I have never been more wrong about anything in my life." The rest of the book explains just as engagingly why she was so wrong. And we will now hear from the author of The Whiteness of Wealth, Professor Dorothy Brown.
Thank you. I'd like to thank the Dean, the Associate Dean, and all the wonderful staff for inviting me to give the Green Lecture and the lovely introduction by Alice. I am in awe of Judge Green, a prominent member of Philadelphia's first Black law firm and an extraordinary judge who, as described by his long-term clerk, was, quote, "a patient, measured man, slow to speak, but quick to listen." Any judge who is slow to speak is truly one of a kind. And easy to understand why he was beloved by his colleagues. I am humbled by the opportunity to give tonight's lecture, and I want to spend my time with you today talking about the value of tilting at windmills. It's tax season, and it's something that everyone loves to hate. But I'm here to remind you that tax policy is a civil rights issue. I begin with an observation. There are serious consequences caused by the myth that tax law is somehow different from other areas of the law. One such consequence is perpetuating the belief that tax law is neutral and objective. To the extent that tax law is assumed to be different, it will not be examined through a racial lens, the way that so many other areas of the law have been. To the extent that tax law is assumed to be different, any disparate impact based upon race will continue to be invisible, unabated, and relentless. I decided in the early 1990s that I wanted to forever eradicate the belief that tax law is somehow different. My mission was to fundamentally change the national conversation around tax policy. That is the windmill I have been tilting at for over 2 decades. My journey began one afternoon when I decided to take a break from class preparation and read a law review article I had been saving for just such an occasion. It was an article written by my friend and mentor, Duke Law Professor Jerome Culp, entitled "Toward a Black Legal Scholarship, Race and Original Understandings." In it, he argued that all Black law professors should analyze whether race has anything to do with the area of the law we teach. I had almost finished reading the article that I thought had nothing to do with me when I saw the following line. There may be an income tax problem that would benefit from being viewed in a Black perspective, but until you look, how will anyone know? Well, as you know from Alice's introduction, before reading that article, it was inconceivable to me that tax law could operate differently based upon race. After I finished reading, however, I called Jerome and made him a promise. I was going to look to see if tax laws impact taxpayers differently based upon their race. Keeping that promise was not easy because I found out that neither the Treasury nor the IRS publishes statistics based upon race. And if the tax experts do not publish the data, then any racially disparate impact will continue but occur out of sight. Because the absence of tax data by race reinforces the idea that tax law is neutral and colorblind, which means that anyone looking to uncover how race could be embedded in our tax laws would be presumed to be on a fool's errand, tilting at windmills. As you know, many government agencies routinely provide race data, but not the Treasury, not the IRS, or at least not until January of this year. But I'm getting ahead of the story. What my decades-long research shows is that when Black and white Americans engage in the same activities, tax policy subsidizes white Americans while disadvantaging Black Americans and results in their financial death by 1,000 cuts every April 15th. Given that there were no published data by race, my quixotic journey could have ended before it began. But I was determined to keep my promise to Jerome, so I had to become a detective of sorts, applying my tax lenses to race research. I came across a report of the U.S. Commission on Civil Rights about the economic status of Black women and saw the following sentence. On average, married Black women contribute 40% to household income compared with only 29% for white women. I realized that Jerome might be onto something. My tax lenses could see with that simple data point that married couples split household income differently by race, and worse, that difference would cause married Black couples to pay higher taxes because of it. Our tax system gives a tax break to households where one spouse contributes very little to household income and penalizes households where spouses contribute roughly equal amounts. That statistic told me that it was likely that married Black couples like my parents were paying higher taxes because they were married to each other, contributing roughly equal amounts to household income. And while many conservatives assure us that marriage is the road out of Black poverty, it is in fact making Black married couples poorer. And because the IRS does not publish statistics by race, we might never have known. There is value in tilting at windmills. What my research showed was that race determines how much we pay in taxes. Taxpayers bring their racial identities onto their tax returns. As in so many activities in America, being Black is more likely to hurt and being white is more likely to help. In the long run, tax policy affects if and how you'll be able to build wealth. That single line in the commission's report led to the first thing I ever wrote about race and tax. It was a book chapter, The Marriage Bonus Penalty in Black and White, which looked at how husbands and wives contributed their income to the household and the impact the operation of filing a joint return, which over 95% of married couples do, had on their tax bill. The chapter talked about how white married couples were more likely to have one wage earner in the paid labor market and one stay-at-home spouse. Those households received a tax cut when they got married. We call that the marriage bonus. On the other hand, couples where husbands and wives earn equal amounts of income are more likely to be Black do not get a tax cut, rather, their taxes increase. We call that the marriage penalty. I followed up the book chapter with a more in-depth article which analyzed Census Bureau data as a proxy for tax data to show household income contributions by husbands and wives. The data showed that regardless of income, Black married couples are more likely to pay higher taxes than white married couples because Black married couples are more likely to live in equal wage earning households. The next thing that helped me uncover the racism that was built into our federal income tax system decades ago was getting the opportunity to teach critical race theory, which taught me how many different areas of the law are not colorblind. The final event that helped me on my quest came once I joined the faculty at Emory University in 2008. My research became more interdisciplinary. I began working with colleagues outside of the law school who taught me the value of their disciplines. The more interdisciplinary research I read, the better and more nuanced my scholarship became. I learned how to ask different questions and came up with more contextualized answers. Historians made me ask, how did this tax law provision make it into the Internal Revenue Code? Sociologists made me ask, how did society's anti-Black racism impact what went on the taxpayer's 1040 tax return? Political scientists made me ask why tax laws benefiting white Americans were enacted and not tax laws benefiting others. Stratification economists taught me to think about the ways that middle and upper income Black Americans were experiencing racial inequity in our tax system. Each of those disciplines taught me to ask more insightful questions that led to different revelations and ultimately to the whiteness of wealth. So the balance of my talk will be about the research published in my book and why I have found value in tilting at this particular windmill. My chapter on marriage, Married While Black, showed that tax subsidies from marriage benefit white Americans more than Black Americans. The research reveals that African Americans are the least likely to marry. When they marry, they do so later and spend less time married than white Americans, and they are the least likely to stay married. The majority of white Americans are married, the majority of Black Americans are not. As a result, tax subsidies for marriage will disproportionately benefit the majority of white Americans who are married. Building upon my earlier research, subsidies for marriage disproportionately benefit white married couples while disadvantaging Black married couples. It begins with the marriage bonus, which provides a tax cut for married couples in single wage earner households, which are more likely to be found among white married couples. The marriage penalty, on the other hand, is the greatest when married couples are in roughly equal wage earner households, when couples contribute 50-50 to household income. Those couples pay higher taxes when they get married than they would have paid had they remained single. Black married couples are more likely to be equal wage earner couples than their white peers. In other words, tax policy decisions contribute to a married Black couple's inability to create more wealth. But answering the history question led me to the Seaborns. What we know of as the joint return did not exist at the beginning of our progressive tax system because taxpayers were taxed on their income as individuals. But in 1927, a rich white couple, Charlotte and Henry Seaborn, along with their lawyers, took matters into their own hands, effectively creating a joint tax return for themselves. Henry shifted half of his income to Charlotte, which lowered the overall taxes the couple paid. The Internal Revenue Service objected, but the Seaborns took their case all the way to the Supreme Court, which rewarded their self-help with a win. Why? Because they lived in a community property state, and legally, Charlotte was entitled to half of Henry's income. That led the court to permit them to treat income that way on their individual tax returns. But that led to rich white Henrys in community property states getting a benefit that rich white Henrys in separate property states did not receive. And that disparity eventually led to the joint return in 1948. But even in 1948, a higher percentage of Black wives worked outside of the home than white wives, which meant it was entirely predictable that the joint return would lead to lower taxes for more married white couples than married Black couples. Our tax system thinks it's equitable when we tax two households with $100,000 of income the same, whether that is a result of two wage earners or one. Racism in the labor market, however, means it often takes two married Black workers to equal one single wage earner. Those households should not pay the same amount of taxes in a progressive tax system. Our system is the opposite of equity. A study of Black and white families over a 25-year period between 1984 and 2009 showed getting married significantly increased the wealth holdings for white families by $75,000, but had no statistically significant impact on African Americans. I believe the marriage penalty disproportionately paid by Black married couples during those years is part of the reason why. And while the 2017 tax cuts temporarily eliminated the marriage penalty for many married couples, it did so by significantly increasing the marriage bonus and by leaving intact the significant marriage penalties in the earned income tax credit. So even if a Black married couple does not pay higher taxes, their white peers get a tax cut that they are ineligible for. In addition, the 2017 tax cuts did not eliminate the marriage penalty for high-income couples, and there is a higher percentage of high-income Black married couples paying the marriage penalty when compared with their high-income white peers who are getting the marriage bonus. There is also a singles penalty in our tax laws. A single worker with $50,000 of income will pay higher taxes than a married couple with a single wage earner who earns $50,000 of income. The marginal tax rate for a single taxpayer is 22%, compared with 12% for the married taxpayer. Almost half of Black Americans are single, compared with just over a quarter of white and Hispanic Americans. As a result, Black Americans are disproportionately paying the singles penalty, along with over a quarter of other taxpayers. My proposed solution is a repeal of the joint return, which would immediately eliminate the marriage penalty and the singles penalty currently being paid by hardworking Americans. No longer would their extra tax dollars subsidize certain married taxpayers that are disproportionately white. The repeal of the joint return would mean that Black Americans currently paying higher taxes would have more money available to save towards building wealth. My homeownership chapter, Black House, White Market, showed the majority of white Americans are homeowners, while the majority of Black Americans are renters. According to the Census Bureau, the highest rate of homeownership was for white Americans at 74%, and the lowest rate was for Black Americans at 44%. As a result, once again, tax subsidies for homeownership will disproportionately benefit white Americans the most and Black Americans the least. Homeownership has been, historically, and remains an asset tied to racial identity. Recent data show that roughly 1 in 10 Americans itemize deductions, and those are disproportionately Americans with higher incomes. The mortgage interest deduction, which can only be taken if a taxpayer itemizes their deductions, is becoming increasingly irrelevant to most homeowners. There are other tax subsidies for homeownership, however, that includes the tax treatment when we sell our home at a gain. Gain on sales of homes can escape taxation for up to $500,000 if you're married, or $250,000 if you're single. Losses on the sale of homes, on the other hand, are not deductible. The loophole for tax-free gains dates back to 1951. By 1950, 55% of white Americans had become homeowners. Just a decade earlier, only 44% of white Americans were homeowners. That explosive white homeownership growth was aided by low-cost, long-term, fixed interest rate mortgages insured by the federal government. that largely excluded Black Americans. From its origins, the tax break for gain on home sales was designed to benefit white homeowners. And by this time, our progressive income tax that began with only rich white Americans paying became almost everyone, including Black Americans, paying taxes once World War II started. So this meant that Black Americans were paying taxes to fund a federal government that was actively discriminating against them. There's a value in tilting at windmills. Established research shows us that the greatest appreciation in our homes comes when we live in neighborhoods which are overwhelmingly white with very few Black neighbors. As the percentage of Black homeowners in the neighborhood increases, home values decrease, particularly because white home buyer preferences, as the majority of home buyers, help establish market prices. While most white homeowners live in neighborhoods with very few Black neighbors, the majority of Black homeowners live in racially diverse or all Black neighborhoods with many Black neighbors. As a result, white homeowners, but not most Black homeowners, are more likely to sell their homes at a large tax-free gain. The homeowners most likely to sell their homes at a non-deductible loss are Black homeowners. Tax subsidies for homeownership, therefore, create white tax winners and Black tax losers. The federal government should stop subsidizing a racially discriminatory homeownership market. We should repeal all tax subsidies for homeownership. My chapter on college, The Great Unequalizer, showed how tax subsidies for higher education contribute to the Black-white wealth gap. Black college students leave college with more student loans than their white peers. The average Black college graduate has $7,400 more in student loans than the average white college graduate. 4 years after graduation, however, Black Americans owe on average $52,000 in student debt compared with $28,000 for white college graduates. And the gap is present across income levels. Not even wealthy Black taxpayers can protect their children from higher student loan debt. The children of wealthy Black parents have higher student loan balances than their white peers. That is true because Black wealthy parents hold assets differently from their white peers. They have more invested in their homes, less invested in the stock market. In addition, Black parents are more likely than their white peers to take out direct plus loans, which have higher interest rates attached. But why does Black college debt grow over time while white debt is reduced and paid off? Black college graduates are more likely to attend graduate school compared with their white peers and more likely to have graduate school debt. Any college debt repayments will be deferred while the student is in graduate school, increasing the principal balance over time. Coupled with income-based repayments, which Black college graduates use almost twice as much as their white counterparts, the result is Black debt balances that increase over time. While created with the best of intentions, deferred debt and income-based repayments are contributing to an ever-increasing Black student debt problem. And tax policy does not help matters here. The deduction for interest on student loan debt is limited to $2,500 per return and subject to income limits. By my calculations, with Black debt at $52,000 and white student debt at $28,000, in the first few years, Black taxpayers are more likely to be unable to deduct all of their interest because it exceeds the $2,500 limit. White Americans, on the other hand, are more likely to be eligible to deduct all of their interest. And the worst of all possible worlds is if two Black college graduates get married because they file a joint return and the $2,500 cap is it. If they stayed single, they'd each have $2,500, but when they get married, they both have only $2,500. Student loan debt contributes to the racial wealth gap. Researchers have placed student debt at roughly 10% of the racial wealth gap when a college graduate is 25 years old, but by age 30 to 35, it explains about 25% of the gap. And I have two solutions. One, increase Pell Grants, and two, student debt forgiveness. According to the Center for Budget and Policy Priorities, Pell Grants cover just 29% of the average cost of tuition, fees, room and board at public four-year colleges, compared to 79% that it covered in 1975. Pell Grants have obviously not kept up with the rising cost of college. Pell Grants are awarded by income, and roughly 70% of Black college students receive them, compared with 34% of white students. Increasing the amount of Pell Grants should enable future generations of Black college students to graduate with significantly less debt. And the funding should come from a tax on not-for-profit institutions with at least $750 million in endowments, who are doing little, if anything, to reduce the debt load of their Black students. I support targeted debt forgiveness for those in households with below median wealth. Debt forgiveness should also include not just student debt, but parental debt, similarly to the way the Morehouse Debt Forgiveness Program was structured. Congress must ensure that any forgiveness is tax-free for those whose debts have been forgiven. And we've seen with President Biden's attempt at debt forgiveness, the legal challenges faced when relief is targeted based on race. My chapter, The Best Jobs, shows that tax subsidies for employer-provided retirement accounts are more likely to benefit white workers. Occupational segregation in the labor market is part of the reason why. Retirement accounts as a tax benefit traces its roots to 1942, when price and wage controls during the war, along with an excess profits tax, encouraged employers to provide non-wage benefits like retirement accounts. Amounts set aside in retirement accounts by employees, and if there's an employer match, those amounts as well, are not taxable to the employee until their expected withdrawal at retirement. If any amounts are withdrawn prior to age 59 and a half, they are subject to an additional tax penalty. Black Americans are less likely than white Americans to work for employers that provide retirement accounts. In the private sector, 56% of white workers work for an employer that offers a retirement plan, compared with 50% of Black workers and almost 35% of Hispanic workers. But working for an employer isn't the same thing as having a retirement account. Less than half of white workers, a little over a third of Black workers, and a little over a quarter of Hispanic workers actually have private sector employer-provided retirement accounts. Black workers are more likely than all other racial and ethnic groups to take an early withdrawal from their retirement account, regardless of income, and pay a tax penalty. One potential explanation comes from research that shows Black college graduates are more likely to send money home to their parents and other family members in financial distress, while white college graduates are more likely to receive money from their parents and other family members that enable them to save more and build wealth. Black college graduates have to make their dollars stretch farther than their white peers, which makes it less likely for them to be able to contribute to their retirement accounts and more likely to withdraw what they may have been able to contribute. Given the low percentages of workers across racial lines with private sector retirement accounts, tax subsidies should be withheld from employers until those numbers increase. My next chapter, Legacy, shows how tax subsidies for gifts and inheritances increases the Black-white wealth gap. The median household wealth of a white high school dropout is greater than the median wealth of a Black college graduate. Part of the explanation lies in family financial transfers. Gifts and inheritances explain about 5% of the racial wealth gap. That study followed families over a 25-year period and showed that white Americans were 5 times more likely to inherit than Black Americans. But it gets worse. Among Black and white Americans who actually received an inheritance, white Americans received about 10 times more wealth than Black Americans. For each dollar inherited, white families were able to use 91% to increase their wealth, compared with only 20% used to increase Black wealth. Again, Black Americans have extended family members who were alive during Jim Crow and received fewer opportunities to build wealth because of government racial discrimination. Black college graduates are more likely to send money to their parents, depleting their wealth, while white college graduates more likely to receive money from their parents, enabling them to build wealth. Once again, tax policy exacerbates the racial wealth gap. Gifts and inheritances are received tax-free. Financial transfers by Black Americans to help support family members are not tax-deductible. Those without wealth do not have tax breaks to help them build wealth. I believe tax-free family financial transfers helps explain why white households with a high school dropout have more wealth than that found in the households of Black college graduates. My solution would be that gifts which lead to wealth building should be included in taxable income, but not gifts that cover family financial needs. In addition, the loophole for income from stock ownership, which primarily benefits rich white taxpayers, should be repealed. But how do we get that tax break? Well, as I mentioned in the beginning, the only people who paid taxes were the richest Americans. In 1916, that meant only 1% of Americans paid taxes, and among them was Frederick Brewster. The Brewsters were the second wealthiest family in America behind the Rockefellers. The Brewsters make the Seaborns look like paupers. In 1916, Frederick Brewster sold bonds at a $2 million profit in today's dollars. In 1916. And he didn't want to pay taxes on that profit. So he argued that he didn't owe any taxes because he was an investor and not a trader. The IRS said he owed $400,000 in additional taxes. He sued, took it all the way to the Supreme Court, where he lost. However, he may have lost the battle, but he won the war because that very same year, Congress enacted a tax break for capital gains, which remains with us today. So within a few years of our progressive income tax system designed for the richest Americans to pay their fair share, we now have a huge loophole for the wealthy because they went out and got it. We know today that the richest Americans receive the lion's share of the benefits from the low tax rate on capital gains, like income from selling stock. Not even wealthy Black Americans benefit from this loophole to the extent their wealthy white peers do. My solution is to tax income from labor the same way that we tax income from stock. And currently, we tax income from labor at the high end at 37%, while taxing income from stock at a maximum of 23.8%. My final chapter, What's Next, provides solutions as well as recommendations for dealing with reality. My first recommendation, you could probably already guess, the federal government needs to publish race and tax statistics. And my windmill tilting is finally paying off. In January of this year, the Treasury Department's Office of Tax Analysis published a race and Hispanic analysis of some of the largest tax breaks by imputing race to tax returns based on certain characteristics, including name and zip code. Their analysis showed, quote, that overall, the benefits of the 8 tax breaks we examined accrue disproportionately to white families, close quote. And regarding the tax break for income from stock, they found that, quote, white families have higher benefit rates across a range of income levels, and among the highest income families, white families have higher average benefits compared to Hispanic and Black families, close quote. In other words, the Treasury report validated my years of research. My ideal federal income tax system would have fewer deductions, fewer loopholes, all income would be taxed under a progressive tax rate system. My ideal tax reform proposal, would be the enactment of a reparations tax credit available to Black Americans as compensation. Can I get a witness? For the decades of higher taxes paid. It would be a refundable tax credit that would offset any taxes owed, and if the credit amount were greater than the taxes owed, the difference would be refunded to the taxpayer every April 15th. It is only an ideal because unfortunately, the Supreme Court would find the tax credit unconstitutional. What the Supreme Court would find constitutional, however, is a tax credit based upon wealth. Enter my second best proposal, a refundable wealth tax credit that can help reduce the racial wealth gap. A refundable wealth tax credit would apply to all taxpayers living in the U.S. with below median wealth, roughly $100,000. A wealth tax credit would help low wealth taxpayers regardless of race and ethnicity. And while it would help white taxpayers in low wealth households, the racial wealth gap means that the effect would disproportionately help Black taxpayers because of the racial wealth gap. In 2016, 83% of Black households had less net worth than the median for white households. So a refundable wealth tax credit is different from the earned income tax credit in that it's measured by household wealth, whereas the earned income tax credit is a function of income. In addition, while the earned income tax credit is extremely complicated, a wealth tax credit would be quite straightforward to implement. It could be a fixed amount that each taxpayer is eligible to receive, eliminating any possible confusion as to the amount of the credit claimed. If the taxpayer lives in a household with below median wealth, the taxpayer is eligible for the refundable wealth tax credit. It could be a tax credit that ends after a term of years or after the wealth gap decreases or continue in perpetuity. The idea of a refundable wealth tax credit is the important point, and the actual details should allow for flexibility in order to maintain or obtain political support. A refundable wealth tax credit could help low wealth family members that are currently being supported by higher income relatives, which is relatively common among Black families. For far too long, Black Americans have paid higher taxes than their white peers, and fairness requires a significant change to the status quo. A refundable wealth tax credit would be a start. But speaking of the earned income tax credit, my work has had a ripple effect. It was said to have been the motivation behind a recent Stanford study which examined actual tax return data on audits that showed Black taxpayers claiming the earned income tax credit are 3 to 5 times more likely to be audited than non-Black taxpayers. Let me say that again. Black taxpayers who file the earned income tax credit are 3 to 5 times more likely to be audited than non-Black taxpayers. That study in turn led Senate Finance Committee Chair Ron Wyden to request a report back from the then nominated IRS commissioner within 60 days of his confirmation to explain how the racial audit disparity came to be and what the IRS is doing to fix it. I almost feel like my work here is done. Almost. In January of 2021, President Biden signed a racial equity executive order calling for government agencies to disaggregate data by race. The Treasury study published in January is a good first step, but time will tell whether it will be a one-off or the beginning of a whole new approach at Treasury. Last fall, I was appointed to the 25-member Treasury Advisory Committee on Racial Equity, or TACR, as we affectionately call it, where we will make recommendations to Treasury Secretary Yellen, who will determine which, if any, of the recommendations to implement. As I close, I often think about my journey to get the Whiteness of Wealth researched, written, and published. Saidiya Hartman, Columbia University professor and MacArthur Grant awardee, talked about finding freedom in her colleagues' low expectations. She stated, "As a Black woman intellectual, I am at the bottom of the food chain. But within that space of no one taking me seriously, there was all this space to work." Her comments resonate with me Others have said for years that my talking about race and tax was a conversation about an imaginary problem. Or as one tax law scholar remarked after I made a presentation on marriage bonus penalty research at a national law professor conference, quote, "Dorothy, everybody knows your work is irrelevant because Blacks are poor and don't pay a lot in taxes," close quote. Yet the reality is that Black Americans, Black taxpayers pay more in taxes because we live in a society where race unfortunately still matters. And every day that we do not talk about race and tax, it remains hidden, invisible to the naked eye. And every April 15th, wealth is stripped from Black families. What others saw as irrelevant, I eventually found to be very real. There are many more today tilting at the same windmill, and that makes me smile. And now it's time for me to find another windmill. Thank you. I think we have a couple minutes for Q&A. Do we? Okay. If anybody has any questions. Yeah, I have some more talking to do. Okay. Yes, ma'am.
Okay, so I had my sorority had it's pink and green, not this. Okay. Just so
Let's get it straight.
let's get it straight. Oh, okay, I'm sorry. Let me use the mic. Okay, so my sorority had a tax thing on Zoom, and I asked the person this question. When Trump changed the maximum amount for itemized deductions from unlimited, basically.
Like state and local income taxes?
State and local.
Yes.
You got it.
The 10,000
Okay.
cap.
Yes. So those of us who are in that middle income category,
Yes.
who work for the state
Yes.
and city government, who live
In high
in
tax
Philadelphia, live in Philadelphia County, pay a local tax that used to be around 4%. It's a little less now, like 3.87, I think. But that money comes out of city, state, and other workers in the city of Philadelphia. So the impact, that racial impact that you're talking about, weighs more heavily on those of us who are of African descent, who are city employees, governmental employees, who can no longer take that state and local tax, the maximum amount, all of it.
Right.
So if you have $20,000,
Right. You're only
of
taking
state-
10.
Yes.
Yeah.
So you grab back what we had before,
Right.
in terms of trying to make that wealth go a little bit farther and make those deductions go a little bit farther. So maybe you get something back on the bottom line. But now there's no more back on the bottom line. It's all you pay because you don't get that maximum amount for your state and local taxes. So when you add that, plus your mortgage interest, plus all the other things that you used to get
Right.
and used to take 100% of,
Right.
you lose.
Right.
And because Philadelphia County and counties in New York and counties in large states,
New
Los
Jersey.
Angeles,
Yeah.
are full of people of color who work for the government. And Trump knows that,
Mhm.
I believe.
Oh, it was in
I
the
believe.
news. It was clear. It was a blue state, red state thing.
Yes, it was a blue state. That's what the accountant said online. He said it was a blue state, red state. I said, well, how do we get back?
Well, the good news is the Trump tax cuts expire in 2026.
I gotta wait till 2026.
Well, here's the thing.
I mean, really?
You know,
I mean,
you know, I'm not
this
the
has
good
been
news
going
queen
on.
today, right?
I gotta wait till 2026.
So
to get
here's the
relief.
thing that there aren't enough votes to fix it. So
Okay, so what the accountant told me online
yes,
on
yes,
Zoom
ma'am.
was that Biden had included something in his Build Back America, Building Back Better,
Build back better, yeah.
Build Back Better, that would restore some of that.
It depended on the day because that kept going in and out of the bill, right?
Oh, so that was a day that it didn't work.
yeah.
Oh, okay.
There are New Jersey members of Congress are pushing for this, right? New York members. So there are some members pushing for it, but there are lots of people pushing for lots of different things. So, with the Trump tax cuts expiring, I see a deal being cut, but I don't know whether the Dems will make that their issue or whether they'll make expanding the child tax credit and making it fully refundable an issue, right? Because
But do they know it?
Oh, they know it.
They know it.
They
Okay.
know it. They
Okay.
know it. Because the senators from the states where their constituents are and members of the House are, basically yelling it all the time. So they know it.
Okay. All right. Well, thank you very much. I really appreciate your taking the time to explain that to me, that I'm going to do this for 3 more years. All right. Thank you very much.
There's a question over there.
Look at race with respect to local and state taxes. Do you know anyone else?
There is a historian at UVA, Andrew Carl, Kahrl, who's writing a book that is looking at state and local taxes and how racially discriminatory they've been. And he wrote a piece about Mississippi. I think it was in the mid 20th century. And the article is like Power to Tax, Power to Destroy. And it showed how this Mississippi town pushed back on their second-class citizen treatment. They boycotted the store. They went to another town to do shopping. And the tax assessor, and then they settled. They brought the town to their knees. They integrated and they got what they wanted. But the tax assessor said, I'm going to make every one of you pay. And every Black person who participated in the boycott got their property taxes increased. And the few Black people who did not participate did not get their taxes increased. And white taxpayers who had made huge additions on their houses didn't really get a significant, including the guy who was the tax assessor assessing his own house. And there wasn't any legal recourse because federal law says as long as you have the ability to sue in state court, don't come here. And of course, the courts in Mississippi gave no relief. So he's writing a book that he may be finishing it this year, where he's looked at it with a long view. And it's just as racially discriminatory. Actually, I would say it's probably more racially discriminatory on the state and local level than on the federal level.
Hi. Sorry. Hi. Thank you so much. So I'm a YNL here at Temple, and this semester I get to take tax law and con law, and we get to learn about how there's different laws that get to pass through the legislature, and they get to make the Supreme Court and the court, because Marbury, they get to be well, we're striking it down because we don't like it. So how do you see and I love that you have all these recommendations on how to change the tax laws to better benefit Black citizens and to change and really change the disparate impact that they've had in the country. But and you even mentioned it, how the Supreme Court does have that power to strike it down and say this is unconstitutional. How do you see how do you recommend moving forward with you have recommendations, but how do you see it turning on a good note if something you recommend to the Treasury goes forward, but they're hey, we don't like this because no, their reparations refundability, for instance, we don't like this because it violates equal protection or something. So now the system just keeps going, it just keeps revolving. What do you what are your views on that?
So the optimist in me says every time the Supreme Court does something like overturn Roe and more people see how political it is, we are at the beginning of a fix for this. Because I think there are many Democrats in complete and abject denial, right? Many of us have been saying for years, it's coming, and oh no, okay, it came, it happened. And you see instance after instance where the Supreme Court that used to be held in high regard is viewed in the lowest, right now it's the lowest number of public support in the history of the Supreme Court, which I'm yeah, because now we're about to do something because people are seeing how outrageous it is. Then you see judges on the Supreme Court with ethical problems, right? And what people learn is they don't even apply the same rules that judges like your husband were subject to. So to me, the fix is a different court. And how we get there is they keep doing the stuff they're doing because it's not sustainable. Because, you know, I'm a law professor. I've been a law professor for 30 years. I've always been a crit. I've always been a cynic, but never has it been this blatant. Usually I have to make an argument to the class. Now I don't have to. I say one word. That's right, Professor Brown. It's all messed up. Okay, I don't even have to say, well, let's look at this. No, that's right. That's awful. So I am optimistic that we are gonna get some court reform because this is not sustainable and we will not take it.
Thank you very much, not only for the presentation, but for the work that you're doing. We really appreciate it, and I hope that someone takes up your call for your solutions. For those who are able, we're having a reception across the way at the Accor Center. Please join us there, and thank you all for coming. Really appreciate it.